I'm Bill Charron. Megan No and I co-chair the art law practice at Pryor Cashman. For those of you who are not familiar with us, we are a full-service, mid-sized firm. And one of the real benefits, particularly right now, is that we have an insurance practice led by our partner, Chris Loeber, who's going to do the laboring oar of this presentation. We've been seeing throughout our various client sectors that these kinds of issues are coming up, and obviously so. Chris, I think, has a unique perspective and take on how to address these kinds of situations, and we just thought this would be helpful for everybody here. This is an indescribable time for all of us. We could all use some more art in our lives as soon as possible. So we're very happy to do this. Let me hand it over to Megan, and then we'll hand it over to Chris.
Yeah, I just wanted to say that there's a variety of different kinds of art market participants on the line. I know we've got some appraisers and some representatives of different galleries. We know that the art industry is being hit by this unfolding public health crisis. And we also have seen a lot of information circulating, a lot of bulletins coming out, a lot of newsletters and emails with written summaries of some of the interesting and unfortunate legal issues emerging from this time. We just thought that doing sort of an in-person meeting and getting together a group of people who are part of the same industry would be helpful. Again, Chris is going to do the heavy lifting here, but I'll just say that working on the transactional side of a lot of different art issues, I'm usually thinking about the insured's perspective before something goes wrong. And so again, Chris is uniquely positioned to work on behalf of insureds from an actual claimant standpoint. And Chris and I have worked together on a couple of different situations involving insurance of fine art specifically. So we're really lucky to have him on the line. And Chris, just take it away.
Actually, one more thing, Chris, sorry to interrupt, but one more Zoom tutorial, that if people have questions during the presentation, also on the bottom of your Zoom screen, you'll see there's a button that says chat. And if you click on that, you can click on either Megan or me and send us questions directly. And then after Chris's presentation, we will read the questions that we've received and do a Q&A for as many questions as you all may have. So thank you. And Chris, all yours.
All right, there you go. Well, thank you guys, and welcome everybody. I know this is a really difficult time for all of us. Obviously, we'd much rather be doing this presentation in a room live with everyone. It makes it a little strange to do this when we can't see interaction, we can't talk back and forth, and there's really not an opportunity to do questions as we go. So here's how I'd like to try to run this. I'd like to give an overview of some of the issues that we're seeing, and then what I'd like to do is talk about one of the most common coverages that may respond. Now, I'm going to start by saying, obviously, we have 50 or 60 people on this call. This is not designed and it's not intended to be a specific piece of legal advice for you, for your specific situation. Instead, what we're finding is many of our clients are confused, and understandably so, about the coverages that they might have, the coverages that might respond. You may be following the news. There are many stories coming out of Washington, D.C. on insurance for COVID-19 related losses. Different states, one of which I'll talk about in particular, are right now debating bills that may impact coverage. So what we're going to try to do is just do an overview. The basic type of coverage we're going to be talking about today is your property policy. And sometimes they're called all risk policies. And so what I'm going to do is I'm going to start by talking a little bit about the policies, a little bit about the types of coverages that are available under the policies, and then how those coverages may apply to the current situation. We can talk a little bit about potential regulatory actions, And then we will close, as Bill and Megan said, we'll close with an opportunity to have you all text in some questions. Obviously, if there are specific questions to your business, it's probably better if we do that offline, because that would be something that we would need to establish a privileged communication over, and we don't want to have those discussions on an open line, but we certainly can make ourselves available for that. So, all right, with that, let me jump into it, and this is going to be, more than anybody ever cared to know about insurance. But the plus side is, if you're having trouble sleeping at night, you may be able to pull out your policy after this, and that'll be a real sleep aid for you. So, the business policies that we're talking about, as I said, generally referred to as property, sometimes all risk policies. It's a form of first-party property coverage, and I'm going to touch at the end on a couple of other types of coverage that might come into play down the road, specifically liability coverage. The basic difference is a first-party property policy covers your own premises, your own business income. A liability policy covers damage that's caused by you to someone else. If your operations cause injury to someone else, bodily injury, property damage, that's a third-party type of insurance coverage. And as I said, we'll touch on that a little bit at the end, but for right now, we're going to stick with the first-party coverage, which is the most likely to respond. First-party property coverage is comprised of two basic types. You have property damage coverage to your physical property, and then you have what's sometimes called time element, but more commonly referred to as business interruption coverage. And it makes sense, because this type of policy is designed, if you have an event that causes physical damage to your premises, then there's an understanding that there will be a need to either replace or repair the personal property, the business property that's been damaged by that event. But then also, as a result of it, you're going to incur an interruption in the way you normally conduct business, and that means you're going to, in all likelihood, see a drop in profits. It's very simple when you think of this, and I'll just give the most common example. If you're looking at a hurricane, or you're looking at a fire, wildfire, earthquake, tornadoes, whatever natural disaster you want to think of. In situations where you are affected by a natural disaster, it's simple to see the effect of that natural disaster on your business. If you have a wildfire, if you're in California, it's very simple to say, my building burned down, my gallery burned down, I lost computers, I lost furnishings. And the insurance company can come in and look at the items that are damaged and say, okay, well, there's a value we're going to put on that, and we'll pay for that property damage. And then after that, you say, okay, there's been property damage. Clearly, there's going to be an interruption of business. And so the second piece of the analysis is, how did this damage affect your business? Things these days are a little up in the air. There is a question, and the open question is whether COVID-19 related infections, for lack of a better term, count or qualify under the policy as damage to your property. Now, the second question is, if you have had damage at your property, what happens next? And then there's a sort of an outside question. If you have not had direct damage at your property, and yet you are impacted by government shutdowns that we're seeing all around the country, does that give rise to coverage? Okay. So what I want to do is I want to talk a little bit about our view on the world here. And I will say, just so everyone knows, Megan mentioned it, but I am a policyholder side attorney. So I'm a coverage lawyer. I've always worked in private practice. I used to represent insurance companies. I did that for the first 6 or 8 years of my practice, then switched, and now I exclusively represent policyholders. So my view of the world is going to be very different than what you hear from insurance carriers. Insurance carriers are going to take a very hard and entrenched position here that there is not going to be coverage. I'm going to talk about that a little bit. And I'm also going to say, well, I think they're wrong. And I'm going to give you some suggestions as to what you can do to make sure that you're not caught in the middle there. So basically, the first question is, can COVID 19 related infections or contaminations qualify as property damage. This is an issue that has come up in different contexts through the years. It's not, clear. I will say that insurance is a body of law that is a state by state body of law. There is no federal insurance law. And so it could vary state to state, policy to policy. There are a lot of variables. That said, there is nothing in these policies that we have ever seen that says microscopic damage doesn't count as damage. And when we're talking about one of the most highly contagious viruses that we've known in modern history, there is a pretty good bet that if you had someone in your premises and that someone was breathing, that you do have spores somewhere on your premises. Now the question is, how do we test for that? How do we prove that out? And all of that is that's something that we'll have to do. But again, there are ways to do that. I won't get into the weeds of that right now. If you don't have any proof at this point, if you don't have any expectation that you do have the virus within your premises, it doesn't mean that you're out of luck on the coverage. Because typically, the way the business interruption coverage works is you have coverage for your lost profits. You have coverage, and that's called your business interruption coverage. Then you have contingent business interruption coverage. And contingent business interruption coverage, it refers to situations where you may not have had physical damage on your premises, but the business partners, vendors, the folks on whom you relied to do your business have had that damage. And the odd thing about it is, as long as your policy covers that damage, even if it didn't happen at your premises, if it happened at the premises of your suppliers or contracting partners, then you may have coverage under your policy for that. Other types of coverage that are generally referred to as additional coverages. Most policies have coverage for civil authority or military action. This is a big one now because obviously we're seeing states and local governments all around the country locking down their areas. You are not permitted to go certain places during certain hours. There are certain places that are locked down altogether. Those of us, I can tell from seeing just a couple of the faces around here, everybody looks like they're in the same position where we're working from home. So obviously we're not able to get into the normal places of business. So the question there also is, well, why is the government shutting it down? Is the government shutting it down because there is damage? Well, our argument is yes, of course. That's the sole reason they're shutting it down. Now, that doesn't mean there's damage necessarily to our property, but many policies say if there is damage within a certain radius, 5 miles is a very common clause that we see. If there's damage of the type covered by your policy within a 5-mile radius of your premises, and you are subsequently ordered by your state or city to shut down, then there's a good argument that there would be some coverage there. One other that I'll talk about, and there are many others. It's we can go on, but for purposes of today, we're just going to talk about the broad strokes. Business interruption coverage almost always includes one other major bucket of coverage, and that's for extra expenses. Extra expenses are defined generally to mean all those additional costs that you incur as a result of an event that you're required to pay to get yourself back up and running as close to normal as possible. Okay? Everybody has obligations under any insurance policy. When you sustain a loss, you have an obligation to mitigate that loss. The idea being you can't just sit back and say, oh, well, this is happening, and I guess I'll just let my insurance company worry about it. What you need to do is get out there and take steps to minimize those damages. And so the insurance policies understand that, and they want to encourage that. And so they will provide coverage for the extra expenses, things over and above that you need to do to get your business back to normal. Okay. Let me talk for a moment. So that's the broad overview of the coverages. Let me talk for a moment about a couple of things that your policies may contain. Sometimes insurance carriers are very blatant about excluding coverage for viruses. And sometimes they put endorsements, and it just has a kind of a very, very 30,000 foot view of an insurance policy. You have your basic terms, the guts of your insurance policy, and then carriers use endorsements or add-ons to the end of your policy as a means to customize the policy. So even though the body of the policy may say one thing, the endorsements that are added to the policy may take away some of that coverage or adjust or amend that coverage that's in the that's in kind of the boilerplate. So there is a broad exclusion out there, and I'm not sure if folks on this phone are limited to folks in New York. I think we probably do have a large number of people in New York, but elsewhere, there is a policy exclusion that basically says we will not pay for any losses of any kind that relate to or arise out of bacteria or viruses. Now, this was a response to the number of other epidemics/pandemics through the years, MERS, SARS, Ebola, all of those events caused the insurance industry to say, hey, you know what, it's going to cost us an awful lot of money if we cover these things, so why don't we come up with a blanket exclusion? So that's one thing, and I'm going to circle back to that in a minute. But there's a second way in which insurance carriers exclude coverage, and it's a little bit sneakier. I mean, my friends on the insurance coverage side don't use words like that. But if you look at your policies often contain what they call pollution exclusions. And so they say, yeah, listen, we're not really interested in covering any losses that arise from pollution or contamination. And if you look closely, some of those policies have a long laundry list of things that they include in the definition of pollutant, and virus often finds its way in there. So even if you don't have a straight blanket virus exclusion, you may have virus coverage that or the insurance company may argue, I should say, that you have an exclusion because virus is part of pollution and pollution is completely excluded. Okay. Now there are I'm saying this in general terms. I do not agree with it. There are ways that we on the policyholder side push back on this. We don't accept these arguments from the insurance industry. One thing that's happening that's very interesting right now is happening in the state of New Jersey. State legislature is debating a bill that would basically go directly to those virus exclusions and take them out of policies that were purchased by any companies that have fewer than 100 employees. And the thinking is this: the virus exclusions were put in by the insurance industry. And typically, when you have an exclusion that's added to a policy, the insurance carriers are doing that because they want to encourage you to buy another line of coverage. So for example, if you have pollution excluded under your property policy, or if you have pollution excluded under your general liability policy, there is a market and you can go out and buy a pollution legal liability policy. So the insurance carriers say, well, we're not going to give you this coverage in the existing policies because we'd love it if you buy a new policy. Similarly, well, not similar, but it's on that basis that the New Jersey legislature is looking at these virus exclusions, and they're saying, hey, you know what? You did exclude these coverages for virus-related losses, but you haven't really made available a product that you could buy to get that coverage. And you indicated to us. Now, again, this is, I don't know this firsthand, obviously. I'm reporting what I'm seeing. But my understanding is that they're saying because this broader coverage was not made available, that it was not fair to have the blanket exclusions included in the policy. So that's something right now that's going on legislatures in New Jersey, because, as I mentioned a few moments ago, insurance is a state-by-state body of law. It's often the case that if one state does something with regard to a particular type of coverage or a particular exclusion, other states may piggyback on that. So we're watching that very closely. And I'm going to tell you why it's important for all of you. Very often in your policies, there's something called the Liberalization Clause. And the Liberalization Clause says, if during the term of the policy, there is a change, and it could be, it varies policy to policy. It could be a legislative change. It could be a change that the insurance company adopts. It could be any number of reasons why there's a change that broadens your coverage, then you automatically get that broadened coverage. Okay, perfect example. We do a lot of work for clients all across the country. We were representing a lot of entertainment clients in Malibu when the Woolsey fire ripped through there back in November of 2018. And after that happened, the losses were so extreme, coupled with the Northern California losses in the Camp Fire. We're working on those as well. The governor of California said, okay, I'm making a change to every policy that's issued in the state of California. The policies often limit your time to sue your insurance carrier. So if you don't like the decision you're getting out of your insurance carrier, you have the opportunity to sue them. The policies often contain a 2-year suit limitation provision, which says, okay, if you're going to sue us, 2 years is plenty of time for you to get through the process. If you don't like what you're seeing, you have to bring suit within 2 years of the loss, or you're not permitted to sue us. Well, the governor came out and said, well, with everything that's going on, we're going to make a change, and we're going to say any of those policies that have less than 3 years are automatically going to be changed to 3 years. And so it was. So that's a real, a recent and kind of real-time example of how legislation, governmental action can come in and change the terms of an insurance policy. Okay, so what does all of this mean? Well, what it means is we're encouraging all of our clients to tender claims. And I want to talk about that for a minute, because sometimes, and you know, again, this is rapidly developing area. I'm seeing things that are suggesting the insurance industry is trying to prevent claims by in some cases, perhaps even denying claims before the policy is even seen, before they understand, you know, what policy is at play. In some cases, there is an effort to discourage policyholders from bringing claims. And listen, it's a practical approach, right? The practical approach is that the industry is looking at literally hundreds of billions of dollars of losses on a global scale here. And to the extent that they can prevent claims from being made by discouraging those claims, well, it's going to be easier for them. Again, I'm looking at this strictly from the standpoint of protecting our policyholder clients. And we're encouraging, even if you think you might not have coverage, we're encouraging you to put in a claim and put it in as soon as possible. Here's why. Policies always have limits on the length of time that you can wait to give your carrier notice of a loss. And it makes sense, because the insurance carrier wants to know as soon as possible, did you have a loss? Are there circumstances that could give rise to a loss? And if so, we need to talk about those. We need to get those into the insurance carrier and start that claim process as soon as possible. Here's what I'm concerned is going to happen if people don't get into this the pool right now on the potential coverage. If you don't tender, you stand on the sidelines and you say, I don't want to do it now. Either I'm getting discouraged from tendering it, or I don't know how to tender it, or I don't want to pay anything, you know, in connection with a tender. Then you're going to stand on the sideline. Developments are going to become more and more visible, whether it's on a regulatory level, whether insurance coverage lawyers like me and my colleagues around the country that do this at different law firms, whether we can make some headway through litigation, and we can establish that, yes, in fact, COVID-19 losses do deserve to be covered under the policies, and the industry is going to have to respond to that. If you haven't thrown your tenders in from the beginning, and you look 3 months, 6 months, a year down the road when things start to develop. And again, I want to set reasonable expectations. I certainly can't guarantee that that's going to be the case. But what will happen is, if you've not put in timely notice and you try to do it later, you are sure to face a late notice argument from your carrier. And they're going to say, well, we would have loved to help you because, yep, looks like we got to cover this stuff. But you know what? You're too late. you knew in March of 2020 what was happening, and you made a decision not to get into the game, and therefore you are not now going to be permitted because it's not fair to us. Okay. So this is the one of my sons is a hockey player. I'm a big Gretzky fan, and he said you miss 100% of the shots you don't take. So what we're doing is we're encouraging our clients to take that shot. There is virtually no reason not to tender a claim. You know, you're not going to be any worse off by doing it than you are by standing on the sidelines and saying, well, you know, there's probably not any coverage, so I'm just not going to do it. That may give rise to questions from people who say, well, but what if I tender a claim and isn't it going to make my premium go up? And what if I tender a claim, isn't the insurance carrier going to see me as a higher risk? Those are all valid questions. There are very simple answers to those questions. When you're talking about a pandemic and you're talking about losses with this scale, everyone's premiums are going to be affected, because what's going to happen is if the insurance companies, the industry is forced to cover this by some type of governmental action, they're going to, you know, they're going to be sure to spread out that pain through different premium adjustments across all lines of policies. Okay. Let me say one more thing, and then we can open it up maybe for questions in a minute. Well, actually, I'll say a couple more things. The first thing is, in addition to advising our clients on obviously the nuts and bolts of their coverage, we've also been working with their marketing and public relations teams. And I'll explain why that's very important. And what you need to be doing is looking very carefully at the statements that you're making to the general public. In the wake of a catastrophic event, it is very common and logical to want to go out to your patrons, to your business partners, to everyone in your world and say, don't worry, we're okay. It's okay, we haven't been impacted. There hasn't been a direct, case anywhere near us. We're okay, we're fine. No, this is not going to have a major impact on us. That's a natural inclination, and it's smart in many ways. But what's going to happen is, if you say that now, and then you see how the situation unfolds, and you later realize that, wow, this had a major impact on my business, and you go to your insurance carriers and say, okay, I've tendered my claim and I've worked up my losses, and I have 7-figure, 8-figure losses that I've sustained as a result of this. The first thing the insurance company is going to do is grab your press releases and wave it right back in your face and say, no, you don't. You don't. See, because when everything's happening, you put out these statements. You said, no, it's fine, no problem. And they're going to use that against you, because that is discoverable evidence in an insurance coverage litigation. Okay. So what we're doing is working with our clients to say, it's very important how you phrase these things. It's not like you want to scare the public and say, wow, don't come to our gallery. We're chock full of this stuff. It's all over the place, right? Now, of course, you don't want to say that. But what you would say is, instead of saying, yes, we're closing down because it's the smart thing to do, or we're closing down simply because we were told to close down, you can say, as a result of COVID-19 and in keeping with the directives of state and local governments, right? Two very different statements, because what that's saying is, it doesn't say that you've necessarily had a direct loss, but it preserves your ability, if you go back and later investigate and determine that you in fact did, then you're not knocking yourself out of play from the very jump. Okay. The next thing I will say, and I guess this is something Bill alluded to this at the top, there are a large number of other considerations here, and I am an insurance litigator. Insurance is my world. I know a little bit about employment issues relating to COVID-19. I know a little bit about leasing issues related to COVID-19. What we're doing is we have teams of our Pryor Cashman partners that are working in tandem to help our clients, and we're getting on calls with them so that we can address any questions they have across the the widespread of this impact. I'm not today giving any well, you wouldn't want me to, and my partners wouldn't want me to give advice on employment issues or leasing issues or force majeure issues, and they all come into play. So speaking solely from the insurance coverage standpoint, certainly if people are interested, we're more than happy to put together those, an additional conference call like this to speak to some of those other issues. But the last thing that I will say here before I close is, and I alluded to this before, there are other coverages that could come into play. This COVID-19 situation is going to be around for a very long time in the insurance coverage world. And while we're concentrating right now on the property damage that it could be causing to you, or the business interruption losses that it could be causing, you may later face liability claims. You may have people that say, hey, I came into the museum and I was infected, and I'm going to come after you because you didn't take appropriate steps. That could lead claims under the directors and officers policies, saying that the manner in which you operated your business was irresponsible, and I'm going to sue the business because it put me at risk or it made me ill. You could have workers' comp claims. You could have employer liability claims. You could have some type of discrimination claim, saying, well, you singled me out. You're saying I was the person that came in and infected everyone, and you identified me, and that caused me to sustain damage, which would be an injury to my person, not necessarily bodily injury, but an injury to my person and my privacy. So there are many areas here. It's a complicated world right now. We certainly trying to handle all of those different areas was beyond the scope of this call. And we can, if people have individual questions, we're more than happy to address those. And so before I close, I will just say something, and that is, and the reason I'm saying this is because every one of these conferences I've done, people go, great, well, it's expensive to hire a lawyer, so what's this whole thing going to cost me? Okay, and obviously we're well aware of that, and we know nobody is looking for a lawyer to go off down some rabbit hole and then come back months later and surface and say, okay, great, can't do anything for you, but here's your bill, right? So what we're working on for some of our clients, because we do understand that many people are going through serious economic hardships, we're trying to come up with a plan for certain size clients who may have just one policy that would need to be reviewed, whereby we would have one-on-one conversations with our clients, where we would do a deep dive into their policy, and we would prepare the letters that would go to the insurance carrier that would tender the claim and put you into play for potential coverage. If we do it in a phased way, what I just described is what we're thinking of as phase one. We would work on a not to exceed fee for that, not a flat fee, but a not to exceed fee. And if we can get through those, the steps that would comprise phase one for less than the not to exceed fee, then you make a decision you don't want to move any further, then any part of the retainer that we have would be returned to you. If you decide, yes, there's something to this, then we would go forward from there. So, and that, I'm just trying to answer questions that I am anticipating people have. That is in no way to say that you have to hire us. If you would like to hire us, we would love to work with you. If you don't hire us, we very, very strongly urge you to hire an insurance coverage lawyer. And the reason for that is because in situations like this, it's just a fact that insurance carriers will look a little more closely if you have already gone and hired an insurance coverage lawyer, because then the carriers know you're serious. They know you've taken a very close look at your policy. They know you're prepared to do what it takes to get the coverage to which you're entitled. So I will stop there. If people are still awake, that's great. I don't know if we have questions, Bill or
Chris, this is Megan. I know that we've received some questions by chat, which we will address in order. But I thought it might be helpful before we do address those individual questions to just sort of, I want to summarize what I'm hearing from you and ask you to tell me if that's correct or not, and to elaborate on it a little bit, because
Sure.
again, the audience for this call consists of a number of different kinds of art businesses. What I think I'm hearing from you is that galleries who have physical spaces where exhibitions have been closed and who have physical property inventory on site, and who may have been impacted by supply chain issues or vendors, businesses closing, like shippers and storage facilities, they sort of have potentially a two-pronged claim, a claim for microbial, microscopic damage to their premises or to that property, as well as a claim for business interruption. What I just want to clarify, assuming that that first part I said is correct, is that for the other kinds of art businesses on the line, some of whom are individual appraisers or art advisors who may already work from their home and not have separate office premises, and who are likely not to have physical inventory because they provide a service to people rather than a good, there is still potentially a business interruption claim. Do I understand that correctly?
Yeah, all of that, right. So you didn't even need me. You could have just done this. That's perfect. Yeah, no, that's correct. It really is, as I tried to say, what we're trying to handle here is in very broad strokes, because everybody does have a slightly different setup. Everybody does have a slightly different policy. But yes, I guess to put it as even more succinctly as you did there, and you did a great job. I think the idea is everybody has some type of insurance that's going to be affected.
Okay. Bill, did you want to do some of the individual chats you received, and then
Yep,
maybe we open up to the group at large?
Sure. I have received some questions. First of all, Chris, thank you very much. Some of these questions are specific. I'm not going to identify any names, but forgive me if I translate your question a little differently to try to make it a bit more general rather than specific. We can follow up specifically if we don't answer the specific question. Taking the first question, Chris, what if people have multiple policies, say a commercial general liability policy and an umbrella policy? Generally speaking, is there a risk? Do you have to kind of pick one to make a tender to, or do you make tender to both, or would that put you in trouble?
No, that's a good question. In these situations, tender under, as many policies as could potentially respond. There is no danger to it. The worst thing that happens is you get a response from the insurance carrier where they say, oh yeah, you know what? You're tendering under your third-party liability coverage or your general liability coverage, but you haven't shown us that anybody's come to you and made a claim, and therefore you don't have, an active event that would trigger coverage, right? So in those cases, it certainly would be, it would be an individual assessment of what the particular client is dealing with. But if there are claims, and certainly there could be. I mean, we could have had people come already and written, emails or called and said, hey, I was just in there the other day, and now, boy, I'm sweating. I'm not feeling so hot. I think you gave me corona, right? So, yeah, that would the individual facts would determine. But as a general matter, there is no harm in tendering, under policies. It's kind of a belt and suspenders.
Next question. While you were speaking, I looked at my policy, and it seems to say contamination is excluded. It also says decontamination costs are covered. What do I do? So maybe to make that a little more general, well, maybe you can answer that.
Actually, I can. You don't even have to. I can actually answer that one, right? So okay. Welcome to the world of insurance coverage interpretation, right? It is very common for policies to have what appear to be contradictory clauses. And that is, we are seeing that across the board. And let me tell you, if you looked a little closer, and I don't know, right? I'm not seeing the individual policy, but my guess is the situation is this. Your policy contains a general limit, which could be very large, and then it contains sublimits. And the other sneaky way that the insurance industry has really protected themselves here is to say, oh yes, we will pay for decontamination costs. If you have a pollutant, and maybe we include virus as a pollutant, I would guess your policy probably does. They say, well, we'll pay for cleanup, but we're only going to pay a little tiny bit for cleanup. We're going to limit what our exposure is. Okay. In a similar way, in many policies, what we're seeing is contamination related clauses, or sometimes even communicable disease related clauses or contagion, losses. And the policy will come right out and say, oh yeah, we're happy to cover that for you. And I saw one, I can say this because I'm not going to identify who it is. One of our large clients has 1 billion with a B in policy limits. They have contamination coverage under that same policy. The contamination coverage is limited to 1.5 million with an M. So you look at your policy and you go, hey, no problem, we're covered because we have coverage against contagious diseases and the losses that flow from contagious diseases. And we have $1 billion in coverage. We're not going to have a problem. And they were none too happy when we went through the policy and said, hey, listen, this is good news, bad news. And the good news is, yeah, you got this coverage. The bad news is these people are going to try to stick you at a limit of 1.5 million. And you can imagine that a company that has $1 billion in coverage is not going to get anywhere near the relief it needs with 1.5 million. So that's I hope that answers the question, but it should give you an idea of why, reading these policies is really a comprehensive task. You need to go through the whole thing, and you need to read them cover to cover.
You mentioned suppliers might be covered. What if my supplier is customers? This person, it sounds like, might be an art advisor. And I think what it's referring to is, you had mentioned, Chris, that if your premises isn't affected, but your supply chain is affected, that might be covered. What if your supply chain is people?
Right, and affected, right. I think that's a good question. And I think really what that's going to turn on is the type of coverage that you've purchased. In a typical business interruption scenario, lost profits is what it kicks in to cover. And what they will typically do is they'll do about a 1-year look back. Sometimes they do more. This is the insurance carriers in a typical covered business interruption context. And what they will say is, okay, you earned X number of dollars in profits over this time period, and that was last year. This year, you have experienced a drop in your profits. Well, why did your profits drop? Now, of course, from our perspective, there is no doubt it's COVID-19. In these situations, and I've been doing this for many years, the insurance carriers will come up with every reason under the sun why it's something other than COVID-19. And what they'll say is, well, yeah, coronavirus, but maybe your quality dropped off. Maybe you had different people that were working with you. Maybe other things happened. You're not on your game the way you used to be. And they'll come up with these reasons to try to say, no, you don't get this coverage because it's not due to this event, right? But so yeah, that would be one where you'd have to see the specific coverage. But I would think that would fall within a business interruption claim, lost profits claim. That's just guessing based on the high level information we have.
Can you talk a little more about some of the regulatory changes underway? Any other states pushing to backstop BI claims? Anything similar to 9/11 happening?
Okay, I'm not sure about the 9/11 reference because there was an awful lot that went on after 9/11, much of which resulted in large, multi-year litigation. So my hope is we can get clarity, although I do expect that. The only other, and we're monitoring different states. I think the industry is focused on New Jersey right now. Not surprisingly, the insurance industry is pushing back very, very hard on what the New Jersey legislature is trying to do. Their theory is, well, we didn't anticipate having to offer that coverage. We didn't price our premium to offer that coverage, and we're gonna do everything we can to try to prevent having to pay out those losses. So that's why there's a big focus in New Jersey. There also have been bipartisan efforts in Congress where there is they are, we'll say, lobbying the insurance industry, even though there is no insurance, federal insurance law. As I said, there are trade groups that operate on a national basis. There are brokers and insurance industry groups, and there's something called the National Association of Insurance Commissioners, which, as it suggests, is made up of the individual state insurance commissioners from around the country. So Congress is trying to appeal to those groups to say, listen, we're your people are hurting out here. Small businesses in particular are really hurting, and you need to do something. You need to step up. So yes, we're seeing general efforts. Nothing has progressed any further than, to my understanding at this point, than the debate that's going on in New Jersey right now.
The last chat question I have asks, is a pandemic different from a virus?
Well, I suppose that depends on who you're asking. Yeah, we would say pandemic isn't a virus, right? Because then we would work our way out of those blanket exclusions. The insurance company, of course, is going to say, no, let's look at this and let's determine a pandemic is what? It's a result of this particular virus. I mean, I don't think that's, and certainly I'm no scientist, right? But I think that that would be one that the insurance carriers would very, very quickly and aggressively push back on. Now, it doesn't mean that's and whoever that is, I love it, thinking like an insurance coverage lawyer, right? How do we interpret these? How do we interpret these policies? That's fantastic. But yeah, it's all going to turn on the precise wording of the policy. But let me just say one other thing there. Just to kind of give folks an idea of how this goes. In our world of insurance coverage litigation, it's often more an art than a science. And I say that a lot, not just because of this group I'm on with today. And what I mean by that is the way that insurance coverage law has developed throughout the country, even though it's on a state-by-state basis, there are some basic principles that cover all claims in all states. And one of the basic principles is, as an insurance company that's drafting these policy provisions, it's not fair for the insurance company to draft them in a vague and a broad way, which they do, and then allow the insurance company to interpret it however they want to deny coverage in the event of a loss. So the way the law has really developed, and our task as insurance coverage litigators is to come up with a reasonable interpretation of the policy. And the law in almost every jurisdiction says if you can come up with two equally reasonable interpretations of the policy, then the policyholder is the one that wins the tie. And that's because they realize, and the fancy legal term is contra preferendum, right? You have to construe against the drafter of a contract. But the law realizes that you have some expectations when you buy these policies, and you have expectations as to what's covered. And it's not fair if you come up with a reasonable interpretation of this policy that supports coverage. It's not fair for the clever insurance lawyers on the carrier side to come back and say, well, maybe you're right, but maybe you're not. We think it means this. Well, okay. Our task is only to come up with something that is persuasive, that is reasonable, and most jurisdictions in this country will say that if we can do that, we win.
All right. Chris, thank you very much. For those who have follow-up questions, please do reach out to Megan or me directly, and we can field them that way. Also, something Chris had mentioned during his presentation, there are similar issues involving leasing, involving labor and employment. If people would like us to organize these same kinds of conferences with our real estate colleagues, our labor and employment colleagues, also please email to Megan and me, let us know, and we will be very happy to put that together. But Chris, this was very informative. Thank you for your expertise. And let me hand it off to Megan to close out. Thank all of you.
Great, happy to help. Thanks for joining, everyone. I hope that was useful.
Yep, don't have anything to add to that. Happy to address any questions you all may have individually, which again, our effort here is to do that on a cost-effective basis. So thank you all so much for joining us, and we hope that this was some useful information for you. Stay well.
Stay well.